Hi guys. So as Jeff said, I know Karina Shea was our scheduled presenter for today, and she had a little issue. She doesn't feel well, so I'm stepping in and we're gonna have a good time together. Don't worry, I've taught the class. It's been a little while, but I've taught the class before. I might not be as rehearsed today, so that'll be fun for everybody. I've been with the firm, again, my name's Emily Gannon. I've been with the firm 9.5 years now, I think. The firm, this is all we do. I know if you guys are here, you're probably regulars at this point. You know that this is all we do is community association work, mostly representing condos, co-ops, HOAs, and handling all that encompasses, elections, contracts, all that good stuff for you guys. So today we're here for the guest restrictions class. This is a hot topic. I know this is and it's fraught with some complications that we're going to go through. And as Jeff said, we only have an hour. The class itself is meant to be just a general sort of 101 informational class, not meant to be legal advice. If you have questions, if there's something I say that maybe was a little confusing, or if you think I misspoke, obviously let me know. We'll try and address it. If you have a specific question about your association, you may want to contact us outside of this. We'll leave some time at the end for the questions, but again, with 343 participants, if you guys all have questions, there's no way we'll get to them all. So, bear with us and be patient here. So, all right, we'll dive in. So the class, like I said, guest restrictions, screening, new owners, tenants, is it worthwhile? So let's dive in here. We're talking about new owners, new tenants, guests. Are they going to count as tenants? Who is a guest? We'll get into all of that. Now, keep in mind, for this topic in general, you guys, it's an interesting one, mostly because the statutes really don't give us any guidance, essentially. Typically condos, as you know, are governed by 718, chapter 718 of Florida statutes, co-ops 719, HOAs chapter 720. And for a lot of topics and a lot of subjects, we can look to the statutes, they give us our guidance and we're all set. This is one of those topics and areas of law where the statutes really don't help us out very much. So what we're looking to today, when we're talking about these screening processes and guests and all of these things, we're going to be looking at your governing documents. So really when I say governing documents, we're talking about your declaration of condominium or declaration of covenants, restrictions, whatever else it may be called in the world of HOAs. Then we're talking about the articles of incorporation, then your bylaws, then your rules and regulations. And that's really the hierarchy. That's the list in order there. Your deck is going to be first and foremost, then the articles, then the bylaws, then your rules. And I like to joke because I think it's funny that I don't know what this reference is, but one of my colleagues who is a little bit older than me, he uses the abbreviation or the expression that apparently is from an old campaign of some sort. A little dab will do ya, and that's how you can remember it. Declaration, articles, bylaws, DAB, DAB. So that's where we're sort of starting here. Most of these things are primarily going to be in your declaration or should be. And we're going to look at whether we're talking about a right of approval, right of first refusal, screening, background fees, security deposits. We're going to get into all of that. So now, when we're talking about your governing documents, certain provisions and certain restrictions are going to have to be within certain documents in order to be enforceable. So, for example, in the world of condominiums, if you want to charge a transfer fee, which really we say transfer fee because that's the term the statute uses, but if that's any fee associated really with the transfer, so an application fee, or whatever you may call it, a background check fee, anything that has to do with a transfer, that's not an estoppel, that's separate, but anything that has to do with the transfer, an application fee, whatever else you're going to call it, there is a limitation in the statute. That is where the statute will come into play. So 718 says that if you want to charge a transfer fee or an application fee, again, whatever you guys are going to call it, that authority has to be in your declaration, your articles, or your bylaws. If you only put it in your rules, and when I say rules, I mean, the rules that the board has adopted It's not part of the declaration, was not approved as an amendment, not voted on by the owners. If you just put it in your rules, that could be subject to a challenge. And that's one of those things that that pops up that people don't realize. Well, we've always charged, $100 for an application. That's always been the way it's done. Well, where's the authority for that? You need to make sure that authority is in your deck, your articles, or your bylaws. If it's just in the rules, you might have an issue. Now, in condo world specifically, there's also a limitation. This is interesting. It was before July 1st, just recently, it was limited to $100 per applicant. Now, as of July 1st, that has changed. So small victory, yay. It now has bumped up to $150 for spouses. Or spouses are considered one applicant, or a parent-child are considered one applicant. So you can't charge the $150 for husband, $150 for wife. It's $150 as an applicant. But either way, it gets you a little bit more money in your pocket, because typically these fees, the whole reason you have them is because you run a background check or there's admin time involved, and ultimately the association's coming out of pocket to process this application. So at least now you have that authority. The transfer fee goes up to $150 for an applicant. Now that's in condominium world, like I said, 718. And that was a recent change, bumping up from $100. For HOAs, this is different. So HOA land, you guys are a little bit luckier here. There's nothing in the statute that limits your transfer fee. So you could charge $100 for an application. You could charge $200 for an application. You could charge, $100 per applicant, and you don't have to necessarily follow the spouses count as one, parent-child count as one. Again, put that in your declaration to be enforceable, but you're not limited in that same way. The other difference too in HOAs, and this is why it sometimes comes up, is if you have a capital contribution. Sometimes the HOAs do require some other amount to be paid to the association upon a transfer or upon a sale, and that limitation would have affected that if you had a capital contribution. So HOAs do not, condos do, and that is something that came from 718. It's not in 720. So that's something to be aware of. And that's often a question we get. Hey, what can I charge an application fee? How much can I charge? Now, other charges, security deposits for renters, for example, they can't exceed 1 month of rent. And the authority to charge that also has to be in your declaration or in your bylaws. Can't just be in your rules, or it's not going to be enforceable for a condominium. And anytime you want to charge a fee, really, that authority should be in your governing documents. You want to make sure you have that authority. Look at your governing documents, look at your declaration, look at your bylaws, make sure you have that authority before you're charging any fees, because you may run into an issue. There was a class action lawsuit a couple of years ago down in Miami against a bunch of condominiums that were charging, various fees, deposits, application fees, transfer fees, background check fees, all of these things that ultimately the court said were being improperly charged, or I think it was actually settled, but that was the allegation. So be careful with that. What about a move in, move out deposit or elevator use deposit? We get that question a lot. In our opinion, if it's a refundable charge, so not something like the application fee that you pay us, and obviously you're not getting that back. If it's a refundable amount, then that's a little different. I think there you could do it by rule, but talk to your attorneys and see what you're talking about there. Basic guidelines. All right. So when we're talking about your application, for example, we'll start there. The first thing we say, first tip, make sure it actually mirrors the restrictions in your governing documents. And I just had this come up for a client, and it just created a little bit of a headache for them. But don't use, if you have a management company and they just have a generic application, it's probably fine. It probably covers the basics, but take a look at it. Make sure it actually is tailored to your community. Make sure the application has references to the restrictions you guys have in your community. Look at, trucks. What about pets? What about, other restrictions you might have in your community? Make sure those are contained in the application as well. We had a client recently that their management company put together an application and just essentially misstated one of the restrictions. They said that you could have a truck as long as it was under X size. And obviously an owner came in, had a truck, relied on that. And the declaration was actually different. The declaration says no trucks, period. So we ran into a little issue there. So if you're looking at your application for sales, tenant, leases for everybody, look at it very carefully, make sure it actually reflects your restrictions, look at your governing documents and make sure that it all lines up. If you have a pet prohibition, this is another tricky one. If you have a pet prohibition, so now we don't want to go fully down this road of pets and assistance animals and all of that. We have a whole class on fair housing as it is, and we can get into that separately. You guys can come back for that class. But if you have a pet prohibition, so now we're not talking about assistance animals, you might want to put in there in your application, do you have a pet? Yes or no. Now, if you're also worried about someone trying to come in with an assistance animal and having that confusion of, well, they told us they have no pet, a pet and an assistance animal, not the same thing. If it's a properly documented and supported assistance animal, it's not a pet. So you might want to say, do you have a pet? And then you might want to have a question, do you have an assistance animal? That way you've in your minds, you've at least answered the question, is this person going to be moving in with a dog? That's really what you want to know. Now, if the declaration requires approval of all of the occupants, you also want to know that you want to ask about all of the occupants. I can't speak all of a sudden. Make sure the application indicates that. List all of the occupants who are going to be in the property. What if it's a corporation that buys the property, or a trust, or some other business entity? Do your governing documents also allow you to review who the occupant is going to be? A lot of times communities will have in their declaration a provision that sometimes they have no corporations, but sometimes they have, if a corporation or business entity is the owner, that approval is going to hinge on who the occupant is, because obviously a corporation can't live in your unit. 1, 2, 3 investors is not living in the unit. You need to know, okay, is Mr. Jones the president of 1, 2, 3, Realty moving in, or is 1, 2, 3 Realty just going to rent it out? That may be relevant for you guys. So look at that, see if you have the authority to look at occupants as well. Now, another thing to look at, know your deadlines, and that's referenced here as well. Look at calendar days versus, business days. Do you have, what was your submission date? Did you get the application all in one day? Did they send you part of it? Did you get sort of other documents trickle in after? Sometimes we get these and they're not complete. You want to make sure you respond to the person, the applicant, let them know, hey, we're missing XYZ. We can't process your application until we have XYZ. So then now, is your submission date when you got that first portion, or is it when the XYZ comes in? We would say it's when the application is completed, but you want to make sure, and again, if this is something you're thinking about even, amending down the road, making that very clear that we don't start calculating, we don't start counting, 30 days or whatever it is, 45 days until we get the completed application. So make sure that's very clear. All right. Transfers subject to approval. Okay. Now, again, we'll sort of start off with a tip here, an overall suggestion. And this depends on your community. Maybe it doesn't apply to you. Maybe you live in, a big HOA and you guys have less of a concern in terms of who's buying for a sale, but maybe you only want to know about leases, things like that. But generally, with a lot of our clients, they want to know everybody who's living there, especially if you're in a condominium. They want to be able to approve, sales, but they want to be able to approve leases. Okay, those are pretty clear cut sales, leases, got it. Now, what about other transfers? What if we're talking about a gift? What if we're talking about an inheritance? What if it's a trust? What if it's a transfer through, essentially through a foreclosure? So look at all of those things. If that's something, and look at your governing documents. A lot of times older language in your governing documents will say essentially that you have the authority to review sales and leases, but they won't specify. So what about a quitclaim deed? What if, Mr. Jones knows that his son wouldn't pass a background check? So Mr. Jones Jr. isn't going to apply. Mr. Jones' dad is just going to do a quitclaim deed and say, well, you don't have the authority to review that transfer. It wasn't a sale. It was a gift, or, that type of thing. So look at that. Can you actually review quitclaim deed transfers and other transfers, gifts, things like that? There is a case that from some years ago where the owner put the parcel into a trust. The trust then conveyed it as a gift to the beneficiary of the trust. The declaration specifically authorized review of sales, purchases, and leases, and that's it. So the board wanted to be able to review this transfer, and they tried, but ultimately court said, you don't have that authority. That authority is not in your governing documents. This was considered a gift. So doesn't work. You don't have that authority. If your language is ambiguous in the declaration, it's going to be construed against the association. So look at what your actual governing documents say and make sure it covers everything that you want to actually be able to review. If you have, and now there's certain considerations as well. You may want to have some exceptions. If we're talking about maybe a gift or an inheritance and you're maybe a 55 and over community, 55 or better, as some people say, you could have an exception maybe if it's a transfer interfamily or maybe a transfer to a trust, because maybe that's for estate planning purposes and you want to allow that. And you don't have to review and go through the whole application process again. That's entirely up to you guys as a board if that's something you want to amend and put in your docs. Operation by law, what we're talking about here is, what if there's a foreclosure? What if Mr. Smith took out a mortgage and just went bankrupt, has no money, has stopped paying, the lender's coming and foreclosing now, and Bank of America is going to take this property back. So ultimately, how does that work? If Bank of America takes title at the foreclosure sale, do we get to approve that? Do they just get it automatically? What if it's Bank of America's foreclosure sale, but like we said before, 1, 2, 3 investors wants to scoop up that property? Do we get to review that application? Do we get to tell 1, 2, 3 Realty that they need to go through the review process with us? Going to depend. Odds are there's an exception. Odds are in your declaration, but you'd have to look. Typically, there's an exception in there if it's a transfer as a result of a foreclosure. What about a deed in lieu? What if Bank of America just takes a deed in lieu from, Mr. Jones? You have to look at your governing documents and see what the story is there. Now taking that one step further, what if then Bank of America or 1, 2, 3 Realty? So let's say they had the exception, they could take title. You guys couldn't ask them for an application, couldn't run a background check. They got it as a result of the foreclosure. We have to accept it. Good. Now, what if 1, 2, 3 Realty wants to rent the property, or 1, 2, 3 Realty wants to sell the property? Well, the exception applied to them, but does the exception apply to the next transfer, to the transfer that from them? You'd have to look at that too. If that's something that's in your declaration, which it is sometimes, because again, they want to sort of promote lenders being able to do these things, that may be something you want to amend out. You want to leave the exception for the lender essentially to take title, but you maybe want to accept or make an exception or cut off the exception at the lender and make sure the next transfer would be something you could review, especially if it were a lease application, or you get to approve the occupants, something like that. So make sure, look at your governing documents, see if that's something that's in there. Keep in mind, again, when your governing documents were drafted, they were done in a way to encourage lending in your community. So there are some of these perks, if you will, for lenders that are just automatically built into your declaration that you may not realize are even in there. And then sometimes there are also exceptions for developers. Same thing. Essentially, they sort of have perks, if you will, in the governing documents built in. You want to take a look, see if that's something you could amend potentially if that's an issue. Now, what about, this is the other question we always get, additional occupants, family members, guests, what are we doing there? Now, we're going to get into guests in its own slide in a few more minutes, so we'll sort of put a pin in that for a second. But in general, do these people have to be approved? How does that work? Do you want some exceptions? Maybe for immediate family members? Look at your definitions. Who is an immediate family member? Do they have to be related? Does it include spouses of those people? What about domestic partners, for example? Maybe that's something we want to update our language and include somewhere somehow. You want to also be concerned about all those possible loopholes that we get. And this happens, obviously, we hear it a lot, where someone says, no, I don't have a renter. That's not a tenant. That's my cousin. So he doesn't have to be screened. He's a family member. So look at your definition, see if we can actually narrow down who we want to say is really a family member. And then who's really, even if they are maybe a guest or they're an occupant over a certain amount of time, even if there is no lease, maybe we want to be able to ask them to do a background check and have them go through the application process and all of that. Maybe we want to also have an exception if the owner is in residence versus when the owner is not in residence. So if it's an issue where maybe you have a snowbird type community and the owner's not there a lot, but these people sort of start popping up and maybe they say, oh, they're family members that are just visiting, just using my unit. Well, maybe you want to be able to do a background check on these people. So if the owner's not there, maybe we adopt a policy, a rule that after X number of days, we're going to treat these people as tenants. We're going to require a background check. But if the owner is there, maybe then we're not going to be as strict and they can be there and, we'll require a different amount of time. Then they have to be there for, 3 months before we need a background check. You can look at all of those things. All right, so now getting into this, can you reject the transfer? Do you have to give a substitution? What's the right of first refusal? Let's dive in. Okay, so consequences of rejecting a transfer or occupancy. First question is, can you actually reject it? Okay, let's start there. Can you deny? Do you have, and this is going to be the question that this all relies on essentially, do you have the right of first refusal in your governing documents? And that is something that would have to be in your declaration. And it would require that essentially, if you deny an application, you're providing a substitute buyer and this is for a purchase here, let's say, or a transfer. So if you are going to tell someone, essentially, no, you cannot sell your property because we don't like this person you're trying to sell it to. If there's no reason, this is where it came from, you can't deny and just say, nope, you can't sell your property. Then the right of first refusal kicks in, you substitute a buyer, maybe the association knows someone who would rather purchase it, maybe the association will purchase the unit, maybe you think this owner is really lowballing and that property value is going to hurt the community, so the association wants to buy the unit and then it will turn around and sell it for a higher amount. Maybe you want to do that, great. Right of first refusal, if that's in there, you can do that. You wouldn't have to have any reason to deny. You could just say, we're essentially going to take this application, this contract that you have, and we're going to substitute in the association or substitute in this investor, and we'll jump in and we'll take over this transfer so the transfer can go through. Now, to refuse a sale, that is what you would have to have. The right of first refusal in your governing documents needs to be in the declaration. So again, the association could disapprove and could have no reason to do it. Just we've decided something, we just don't want this sale to go through. But if you're doing that, you have to provide the substitute buyer. And it could be the association, or again, could be an investor or whoever else. Now, there is a narrow exception case law has allowed. This was in that Coquina Club versus Mance case down there, where it says facially qualify. Well, what does that mean? Okay, so that case, this is the easiest way to put it all together. In that case, this was a housing for older persons community, 55 or older. Now, I'm sure you guys already know, but 55 or older communities, at least one permanent occupant has to be 55 years of age or older in the unit. And under no circumstances can one of the permanent residents be under the age of 18. Can't have children in the community, essentially. They can visit, they can, come hang out with grandpa and grandma for a little while, but can't live there. And that's under fair housing. That's how it's set up. That's how it works. Now, in this case, the Coquina Club, it was a housing for older persons community, which again has a certain designation, has to be registered, all of that good stuff. a family that had small children applied and wanted to purchase in this community. And the court said, since the purchasers did not facially qualify, the association was not obligated to provide a substitute purchaser, because in that case, on the face of the application, these purchasers did not qualify to move into this community. There was already a violation. They were already telling you, we're trying to move into a community that doesn't allow children with children. So automatically that was a problem. Obviously the board couldn't allow that. And essentially that's now been expanded slightly to say, if there is if you don't qualify, if on the face of the application, you don't qualify, you can then reject the application without triggering the obligation to provide a substitute buyer. That's the big linchpin there. So you have to look at your governing documents. If there's something, now housing for older persons community, that is a very clear restriction, crystal clear. You can't move in if you have small children. That's just how it's set up. Not a question there. But if there's something else, and this could expand to other communities, if you have a certain restriction where you don't allow commercial vehicles, and these people have indicated on their application that they have multiple commercial vehicles, those are the vehicles they drive. It's a plumbing truck or a painting truck, and it's all marked and it has ladders and it's all the good stuff. Maybe that on its face, the application says, well, you would be in violation of our governing documents, so you don't qualify to live in our community. That would give us possibly the basis to disapprove. But look at your governing documents and again, talk to your attorneys if that's something that comes up. There was another case where, there was a limitation that you could only have 2 units per owner, and this purchase would have been the third. And if that's in your declaration, you're limited to 2 units. Mr. Jones owns 101 and 102, and Mr. Jones is applying to buy 201. Well, that's again going to be a violation. You already know. You can tell on the application, if that's the restriction you already have in your documents, then that seems pretty clear. You would be able to essentially reject that without having to provide a substitute buyer. Now, okay, criminal history and financial history, not as clear. We'll get into that a little bit more. So now, grounds for disapproval. Right there where it says good cause, here's why. So if what this sort of turns on, your ability to reject an application without having to provide that substitute buyer, turns on whether or not the application qualifies, okay? So what we're looking at there is, if you put certain language in your governing documents, if you amend, you add some language to your declaration, where maybe now you put reasons that would give you to disapprove, which we just call good cause criteria. If you establish this criteria, this is what the board is going to look at. So maybe you put some information about financial history, economic standing information, criminal history, all of those types of things. This is the criteria we're looking at. Then you have that in your declaration. And when you're comparing the application, you can say, hey, the application doesn't match, or, it doesn't sync up to our good cause criteria. It doesn't qualify because of that. So now that sort of is I don't want to say runaround, but then if that is the case, you don't have to provide the substitute buyer because now they don't qualify under your governing documents. But the key there is that you have to put the good cause criteria in your declaration. You may have some generic language already that lets you look at criminal history or lets you look at financial history. Typically, there's some language in there that, sort of says to protect the community and protect the property values and establish a community of congenial residents and things like that. That might be enough to say, okay, we're going to look at criminal history, or okay, we're going to look at financial history. But again, talk to your attorneys, because that's a key point. Now, when we talk about criminal history, I guess we'll get there in a second. I'll come back to that in a second. But another one you want to consider: financial history, criminal history, but also history of the failure to comply with restrictions and with your governing documents. What about outstanding fines, things like that? What if you have an owner that, or you had someone who was a tenant, and when they were a tenant, They were a problem. They had parties by the pool. They were loud. They left their trash out. They, never followed the parking rules. They always had guests that parked in the, on the swale and whatever else you come up with when they were a tenant. And now they're trying to buy and they want to live in the community full time. Well, if you have a history that you've already documented that they've failed to comply with the restrictions, maybe that's something that you would say, okay, that's good cause to say we're rejecting this application. We already know that you don't like to follow our rules and regulations here. So that's something that we say, very important. Look at your declaration, possibly consider doing an amendment to add in that good cause criteria that gives you a basis to now deny sale applications without having to provide the substitute buyer. Okay. Now, what about gifts, devises, inheritances? Okay, so this is another one where, maybe you did have the authority to review, but maybe you could keep someone from occupying the property. You can't necessarily prevent them from owning. Maybe there's some restrictions there in terms of inheritance, the housing for older persons restrictions. Maybe, maybe grandma, grandpa pass away and they leave their property to their 30-year-old granddaughter. And now for housing for older persons, again, one permanent occupant needs to be at least 55 years of age. So if the 30-year-old now wants to essentially solidify this gift or this inheritance or whatever it is, you may be able to say to her, well, you can own it because she can. It has to do with occupancy, not ownership. But you can't live here. Sorry, it needs to be someone who's 55 or older. That's possible. That's an option that might be in there. And then we say the transfer after the fact. What if you find out essentially, that, hey, Mr. Smith, his unit's now in the name of, Smith LLC or a completely different name. But he didn't tell us, and we were supposed to review that. We're supposed to be able to see what the story is there. Now, really, the question is going to be, so can we deny it based just on that? Hey, they didn't tell us, they didn't get our approval, so automatically rejected. No, that's not really going to fly. You don't want to just say it's automatically rejected. Take a look, send them personal letter or send the owners a letter and say, hey, you did this transfer, not sure if you realized, but you actually were supposed to get our approval. So please fill out an application. And you can essentially, after the fact, approve it if there's no issue. If something does come up in the application process, then that complicates things and you may have to ask them to undo what they did, which has happened before. Sometimes there are associations where, an owner transfers it into, like I said, Mr. Smith transfers it into Smith LLC thinking, well, I need to do some things with my assets, or it's estate planning. That was my plan. But then lo and behold, didn't realize that the declaration prohibits corporate owners. So then we have to inform him, hey, Mr. Smith, you can't have it in the name of a corporation. You're going to have to undo that transfer or transfer it into a different entity because essentially the declaration prohibits corporate owners. So, and let them fix the problem. Let them know it's a violation, let them fix it. All right, potential liability. Okay. This is where it all gets very interesting for you guys. So discrimination is really the battle we're fighting here. Now, when you come up with your good cause criteria, when you're looking at these sale, lease, transfer applications, I am sure you do not have any, ill intention. You're not trying to discriminate against anybody. However, you have to be very careful that that's the claim you're going to be facing. Now, in terms of criminal history, HUD issued an opinion a couple years ago now, and we have more about it on our website if you guys want to go and actually read it. But essentially the way they came around to say that there is a disparate impact on protected classes when we're looking at criminal history. So essentially, we have to be careful because certain classes are affected more when we look at criminal history. And it's just essentially a disparate impact. So it impacts one group more than another. So in order to sort of make sure that we are doing this properly and it can't be a discriminatory policy, we tell you, you know, you can't have a policy in place that says if there's any criminal history, we're denying the application. And this goes for sales, rentals, anything under the sun. If you say, you know, if your policy or your rule is any criminal history, we deny, that's it, too bad. You might be on the wrong side of a discrimination claim. You want to have a policy in place that actually says we're looking at this on a case-by-case basis. We're looking at the recency, the seriousness, and of the offense, and essentially whether or not there was a conviction or a guilty plea. And you want to keep in mind a couple different things when we're talking about criminal history. I mean, now, again, don't have a blanket policy that just says any criminal history is a no. That's a bad policy to have in place. You want to have one that's a little bit more tailored to say we're looking at everything on a case-by-case basis. And you really do want to look at it on a case-by-case basis. If you get an application, you pull a background check and there's a criminal history and it's a flag of, you know, from 25 years ago, this person had a felony conviction and it was cashing a bad check or, you know, writing a bad check. And that might have been a felony 25 years ago, but realistically, okay, what are you doing to protect how does that relate to protecting your community at this point? If it was 25 years ago, and if that was the nature of the crime, that seems a little silly. So that's probably not going to be sufficient. If it's, you know, a recent crime, and again, we say seriousness. So we are looking at if it was a misdemeanor charge or a felony charge. If we're talking about traffic tickets, don't even look at those. That doesn't really count. But misdemeanors, felonies, you really want to look at just felonies essentially, unless there's a lot of misdemeanors, then maybe there's cause for concern. But again, case by case basis. You know, years ago, possession of marijuana was considered, I think, a felony in some states. Now it's not even illegal in some states. So, you know, you need to look at all of those things, all of those factors if we're looking at criminal history. And then the question always becomes, well, why do we care what HUD's opinion is? Who's HUD? What does that matter? Why you're just saying things and we don't even know what you're talking about. HUD is the agency that investigates claims of Fair Housing Act violations. So discrimination claims, which again could be based on various protected classes, which includes, you know, race, national origin, religion, disability, and familial status. So keep in mind, there are some additional ones based on which county you're in. Sexual orientation is included in, I think, Miami. Disability is going to be a big one. If we're talking about assistance animals, maybe a reasonable accommodation that someone might need. And again, we have a whole class just on that. So if someone has an assistance animal and you deny their application because they have an animal, you're going to run into some problems with the discrimination claim potentially. If that is the whole reason and you're a no pet community, this person indicated they have a pet. Well, did they indicate they have a pet or did they indicate they had an emotional support animal or an assistance animal? If that's the case, investigate that, ask them for the documentation, make sure it is it's a proper request. And if it is, then you can't deny based solely on the fact that they have the assistance animal, or you're going to run into a discrimination issue there. So make sure, because that is a hot button one. We get that a lot. People will say, well, we're a no pet building and this person has a pet. So problem solved, easy peasy. We can say no, we won't run into an issue. Well, no, don't necessarily do that. Make sure you actually investigate, ask them if it's an assistance animal or an emotional support animal, and ask them to support that request, because now they would be asking you for a reasonable accommodation to the pet restriction or to your pet prohibition, if that's what you have. And they are disabled in this request. So they're entitled to, if they have the documentation to prove it, to request a reasonable accommodation to that restriction, to that prohibition. And they're allowed to say, hey, I have this disability, this animal helps me. And because of that, to enjoy my home, I should be allowed to have this animal, and and now I'd like to rent or buy or whatever it is in your building. And you can't just based on that say, nope, we're going to deny it, or you're going to run into a big discrimination issue. Now, keep in mind too, and this is a separate issue, Fair Credit Reporting Act issues. You don't want to disclose any of the information you come across if you're running these background checks, these criminal history checks. And also, these applications are supposed to be kept in your official records, but they are not open for inspection. So that's another thing to be aware of. You're getting information when you run background checks, run credit checks, you're getting sensitive information. Make sure you're keeping that in, a locked cabinet or a file cabinet that not everybody can go through, because that's protected information. It's not open for inspection, even though it's an official record that you have to hold on to. Another thing to be aware of, Miami-Dade, there's a human rights ordinance, which essentially says that you have to give notice to the owner and the applicant and tell them if their application is incomplete, let them know if there's a reason that you're disapproving. And again, we can help you with that. It says specific reason, but you can sort of, we can help you phrase that in the best way possible. Your deadline to let them know that if something's missing is 15 days. And then it's 45 days to respond if you're gonna disapprove. And those are timeframes that you have to be aware of in addition to whatever timeframe is in your governing documents. So if your governing documents say that after an application was received, if there's no response within 30 days, it's deemed approved, be aware of that deadline, but also be aware if you're in Broward or Miami that you have this ordinance that you have to comply with, and it has different deadlines and you have to follow both. All right. Guest occupancy. So again, this is a tough one. This is the one where we run into issues all the time. This is the sort of the loophole problem where people say, but wait, is it a guest? Is it a tenant? They say it's just family visiting, but we think it's really a tenant. And obviously with Airbnb issues and VRBO issues, this is something that comes up a lot. So we say, for immediate family, things like that, you want to have a definition. You want to put it in your documents, who is going to be considered a guest, who is going to be considered a tenant after X number of days in the unit. Now, maybe we're treating every guest as a tenant. Doesn't matter if there's rent being exchanged. We don't necessarily need to see a lease. We don't need to know what the rent is. We just know that if you are a person living in this unit for X number of days, we're going to treat you as a tenant and we're going to make you do an application. We're going to do a background check. Full, same process you would do with a tenant. Now we say put that in your declaration, that is safer. So maybe if it's if it's someone who's in the unit for 25 days in any 365-day period, we're going to treat them as a tenant. We call them a tenant, even if they don't, they're not paying rent, we don't know if they're paying rent, and they have to be approved. They have to go through the application process. Now, keep in mind, you may want to have exceptions for family members, maybe immediate family members only. Maybe then you don't require that they go through the background check, but maybe you do. Maybe you want everybody to go through a background check. Maybe we look at it and say, if an owner is in residence, we'll say, you get a longer period of time to say before we're going to say you need an application in to be submitted. But this is the one that always we run into loopholes where people say, but we screen everybody, but then someone will always say, this is my cousin, this is my, this is my brother-in-law. He's staying in the property, but he's not a tenant. So this is the loophole. If you want to fix that loophole in your community, if you run into this problem, that's something where we say, talk to your attorneys, think about drafting an amendment to your declaration to clean this up so you can have some leverage and you can have some restrictions in there that you can really rely on. Occupancy limitations, the number of people in a unit. This is also an interesting sort of hot topic. There are certain codes, ordinances that owners are going to have to follow either way, but what about, could the association have their own, or how does that work? We warn you on this one too, also be careful. You might run into a discrimination claim without realizing that you're doing it. Familial status is a protected class. So now, there was a story with, a family of 5 applies to live in a 2-bedroom unit. The documents say only 2 people per bedroom. So the board thinks to itself, well, 5 people, 2 per bedroom, 2 bedrooms, that means 4 people is the limit. So we can deny, right? Well, depends. You might run into a discrimination issue. Are there children involved? Because do children really count as the same as an adult? In the world of ordinances, not necessarily. Broward County, if a child is under 10, they count as half a person for purposes of occupancy restrictions. So if you have a restriction like that, maybe think about being a little bit more specific. Instead of saying no more than 2 persons per bedroom, maybe no more than 2 individuals over the age of 18 per bedroom. Then you don't run into a familial status issue. In the example, actually, the case was a couple that had a baby and they applied to live in a 1-bedroom unit. And the board said no, because we have a limit, 2 people per bedroom. And essentially went to court and the judge said, that was no good. You should not have rejected it. Baby is fine. So familial status, there was a discrimination issue, should have been approved. Now, we'll wrap it up. I know we have a few minutes for questions, but essentially practical considerations, access control. This is how you're going to really sort of, I don't want to say crack down, but this is how you're going to know what you're doing, how you enforce all this stuff. Do some surveys, figure out who's living in your community. If you have lease renewals, make sure you actually enforce them, because we run into communities that say, oh, I think that unit's been rented for the last like 4 years. I don't know. I mean, I don't know who's there. I don't know if they still have a lease. Make sure you're keeping track. If you want to review tenants and you want to review leases, then you need to know when the lease is going to expire. You need to let the owner know, hey, we need a new lease, because now we know we're coming up on the end of the lease. If your person's staying, they need a new application, or, treat that renewal as a new lease, as a new application, and all of that if you want, and make sure you're actually following with it and staying with it, unless you don't want to review leases, and then you might run into that as an issue for you guys. Now, use of facilities, common elements, you can prohibit dual usage. So if an owner is renting their unit, you can, the unit owner has a fob and they give the tenant, and the tenant gets a fob, you can shut it off so that only one can be using it at a time. So they're not both hanging out by the pool. That may help you narrow down, again, who's there, who's using the facilities. Security is a big one. If you require vehicles to be registered, that's going to give you a good idea of who's in the community. Have some parking rules, maybe stickers, decals, all of that. If you adopt a policy, a parking policy especially, make sure you actually enforce it. Yes, we require stickers, but if you don't have a sticker, we don't do anything about it. Well, okay, then where's that getting you? So, you can send notices of a violation. You can tow vehicles too, keep in mind. That's an option that would get someone's attention, but you want to make sure these are things you're actually enforcing across the board. So you're not picking on anyone. There's no, threat that, or possibility of someone saying, you're just picking on my tenant. Nope. Every car has to be registered. Every car needs to have a sticker. And if it doesn't have a sticker and it's not parked in, whichever spot, then it gets towed. Make sure you're applying that across the board. Key fobs, same kind of thing. Do you have gate cards, access cards? Make sure you track who has them when they, if they're shut off. If a tenant leaves, you get it back or you shut it off, whatever it is. Do your guests have to be registered? Do you have a security guard? These are all things to help you sort of keep in mind who's there and when. Now this rolls into enforcement essentially. So again, if you have people that you think are not approved, tenants, guests, occupants, whatever they are, and you have the authority to be reviewing that, send them a demand letter. Hey, these are, we know these people moved in. We saw them with the moving truck. We're supposed to be reviewing any sale or lease applications. Send us an application. Make sure, Mr. Smith comes to the office and fills out an application. Send them a letter, put them on notice of the violation. It's treated the same way as a violation. So, send them the notice, give them a chance to come in and comply and fix it. If they don't, then you can litigate. You can sue them essentially over it. And maybe it's to sue them to get rid of the people, or maybe it's to sue them just to get an application in. You'll have to see. Can you evict? Can you just evict the people if they're a problem or if they never filled out the application? Maybe, but you have to look at your governing documents. Your governing documents might authorize you to step into the shoes of the owner. Typically, you'd be suing the owner because the owner is the one who didn't comply and didn't follow the rules and the restrictions and didn't do the application. But what if it's a problem tenant? They did apply, but they're now a problem tenant. They've broken a million rules. The owner doesn't listen. You've sent letters. Owners may be abroad. You don't know where they are. They're not doing anything. How do we get rid of this problem person? If your documents allow, you may be able to step into the shoes of the owner and evict that problem person. And then maybe assess the amount that the attorney's fees cost you guys against that owner. Look at that. That might be something you want to amend and put in your documents if you don't already have that authority. What if it was a non-approved transfer? So what if, like I said before, Mr. Smith moves his unit into Smith LLC? What do? We found out now it's in Smith LLC. What do we do? So again, send them a letter, start it out as a violation. Hey, you transferred this property, you didn't get approval. Please fill out an application, all of that. But right, if it's typically the docs will say that the transfer is considered void if it wasn't approved. So that's something we sort of throw in the letter. Hey, this transfer is going to be considered void unless you subsequently get approval. So make sure you do the application. And again, you may have to sue them ultimately to clear up the title or get them to reverse the sale if it was a problem. If they put it in the name of, 123 Realty, but you guys have a corporation restriction, you might have to sue them to get them to undo that. Now, essentially, I know we're running a few minutes behind because I just want to have a couple of minutes for questions. But in conclusion, first things first, primary thing here that I'm going to tell you, check your governing documents. Confirm, create the authority, look at what you have in your governing documents now. Make sure it covers everything that you want it to cover. Make sure you really do have sale approval, lease approval, transfer approvals, quitclaim deeds, gifts, all of that stuff. If that's what you want to be able to review and that's what you want to be able to approve or disapprove, make sure you have the right language, make sure it covers everything. If that's not what you want, if that's not what the community, if that's not what works for the community, that's fine. But make sure your governing documents match what everyone wants. And I will be honest with you, we've had communities where the board has said, hey, we want to reject this sale because of XYZ. And then we look at the documents and we say, wait a minute, you don't even have the authority to be asking them to do an application. There's nothing in your governing documents for that. So you definitely can't reject it without a possible issue. So what's going on here? And then, sometimes we get the response, well, we've just always done that. And everyone fills out an application and no one asks us a question about it. Well, as long as they were always approved, it wasn't a problem until it was a problem. So look at your governing documents first. Start there. Make sure you have the authority you think you have. If you don't, talk to your attorneys. Think about creating that authority, amending your governing documents, and then establish your procedures of how you're going to handle this. Is your management company going to do a lot of the legwork, if you will? Are they going to handle the application? Are you going to set up a screening committee, as they say, or an interview committee? I prefer that term. Try not to say screening. It's not great. Say interview instead. When you do the interview, if your documents do require an interview, maybe don't call it a screening. Maybe say it's a meet and greet. You've already read through the application. The board is already going to approve them. And now you're going to meet them face to face and go over, the rules. And that's why I say, call it an orientation, call it a meet and greet. That way, there's not a question. If you aren't sure if you're going to approve them, and then you do a meet and greet, or you call it a screening, and then you reject them, they now may have an issue to say, well, but they only rejected me after they met me. Maybe it was something with the way I looked. Maybe it was something with, and then now you're running into issues of possible discrimination claims being made. So be careful with that. That's another one that we like to warn you with. And to take that even further, I know a lot of times the applications ask for a copy of the driver's license. Maybe the board members don't need to see what the picture of the person looks like. Maybe just, management can have a copy in their file. Board members or the committee doesn't need to know what Mr. Jones looks like, because again, anything that can sort of take away the threat of a discrimination claim is better for you guys, because you want to make sure you're making these decisions based on the criteria you have in your documents, and there can be no question that it had to do with anything else, any protected class, any of that. All right, let's look at some questions for a second here.
Emily, before you look at questions,
Yes.
Just one quick thing for those of you for course credit, you don't need to stay on for the Q&A if you don't want to. So I'm right now about to put in the evaluation link into the chat. So check out your chats for the evaluation. I just hit enter. It's right there now. And I'm going to share my screen really quickly for the latecomers. The evaluation looks the same. This is what you're accustomed to. Okay. Here's the link to download the course materials. If you haven't already done so, you click on that, you can download the slides. And then once you hit submit to your evaluation, you hit submit, you're going to get a confirmation screen. Okay, with your, it'll have your name, the name of the course. This is now your certificate. Okay, so if you want to print the certificate and have it for display or give it to your board or whatever it is, you right click on top of it, hit print, and then you can go ahead and print it, save it, file it, whatever you need to do. This is sort of you're our test audience today. You asked for quicker receiving of these certificates, so this is what we're trying. So go ahead and do that. And with that in mind, Emily. Oh, for anybody who phoned in, once we verify that you run for the entire time, you will get an email with that link, because you obviously cannot see that link right now. So for anybody who phoned in, we'll make sure you get that link once we verify you're on for the entire time. Back to you. Sorry for the interruption.
I'm not gonna lie, I didn't even know phoning in was an option. Who knew? Great. That's fun. Okay. All right. So I'm just going to go through a few of these questions. Some of them, again, if they're too specific, you know, I hate to do it to you guys, but you'll have to, you know, again, contact me later or talk to your attorneys and go back to that. So someone did ask, how does an HOA enforce these rules? What options are available? I know we touched on a little bit of that. Essentially, you treat these as a violation. If there is someone who, you know, moves in who didn't get the approval, you send a letter to the owner. If it's a tenant, if we think it's an unapproved occupant, you let them know, hey, you had people move in, they're living in your unit. Looks like, you know, maybe they're tenants, whatever it is, again, whatever authority you already have. So make sure you have that first. Send them a letter. We need these people to go through the application process, have them submit an application by X date. And then if they don't, then possibly now we're going to have to sue them ultimately to either get rid of the people or get these people to submit an application. And then again, like I said, some other options, and this is usually what will catch everyone's attention, if you have those parking restrictions, vehicle restrictions, things like that in place, and ultimately you can say, well, we only register vehicles for approved occupants, and this person isn't approved. They just sort of showed up. They haven't done the application yet. So, you know, we're going to tow them, because that's what we would do with any vehicle that just shows up in our community. That's usually enough to sort of scare someone to say, okay, wait a minute, what do I need to do to get a parking pass? Oh, I need to fill out an application. I didn't realize. Okay, let me fill out the application. Please don't tow my car. That's a big one. That usually sort of carries a lot of weight. But again, that has to be something that you've been doing. You've been, you know, you tow regularly. This is something you uniformly enforce, you timely enforce. You're not targeting this one person. This is, if any mystery car showed up in your parking lot, that would be your procedure. So send a letter first. Towing is another option. And then if they don't comply, you may have to sue them ultimately. And really, if you sue them, it is a violation of the governing documents. You are entitled to the recovery of attorney's fees if we're talking about a violation. So keep that in mind too. Now, and someone said calculation of dates. If there's a number, do you calculate by calendar or by working days? I would say the default essentially should be, if it just says days, consider that regular calendar days. If it's business days or working days, it should specify business days or working days. And since that the default of business days or working days would be longer, you should default to just regular calendar days if it just says a number. Someone said on the application, can you say, do you have a pet? Can you ask for the animal's description, breed, weight, etc.? Yeah, I would say go ahead, ask for that, because ultimately it is the same thing as saying, okay, do you have a pet? And now maybe you do have a restriction in your community where pets can only be over, you know, under X size. That's a good one to keep in mind. But again, keep in mind now, if it's an assistance animal, if you do have a restriction like that, so maybe you're one of those communities that says, yes, we allow dogs, we allow one dog, just has to be under 20 pounds. Okay, and someone checks off, you know, yes, I have a pet. His name is Spot. He's a Great Dane. He, you know, and that's all they put, or they put weight, you know, 110 pounds. Again, now you know automatically they're going to be in violation, but do a little investigating. Maybe they answered that way, but maybe that's an assistance animal. If it's an assistance animal, those pet restrictions aren't going to apply. Now, again, that's if it's properly documented and supported. But yes, put that on your application too, so you do get more information. Let's see. How can a building composed of more than 90% of adults become a 55 and over community? That's a separate question, sorry. All right, can we raise our application fee via a reasonable rule change? You may be able to, and now that's something where you'd have to look at your governing documents and see where the application fee comes from. If your declaration says, the board can charge an application fee or transfer fee at the highest rate allowable by law, great. Then you could adopt by rule, okay, we're going to bump up our application fee to X, and you could establish that as a policy or as a rule. If your declaration locks you in, if you have old language and the declaration says, the board can charge a transfer fee of $50 or $100, then that's what you're stuck with, unfortunately, unless you amend the declaration. So it depends on what your governing documents say. Let's see. All right, some of these are very specific, so I'm sorry, guys, we can't really get into this. All right. Is a trust considered a corporation regarding denying a sale? Interesting. So again, that's something that would be very document specific. Typically, if there is a corporate limitation, so a restriction in your governing documents that say, no owners shall be a corporation, you have to look at that provision, see what that language is, because a trust isn't a corporation, but it may say no corporation, partnership, business entity, or other non-natural entity. It would really depend on the specific wording. And sometimes, like I said, we'll usually allow for an exception in most 55 and over communities. We'll allow for an exception if it's, if it's a corporate restriction, but it's a trust that's meant to be set up for probate issues and estate planning, a revocable trust. Sometimes we'll put a specific exception for that. What if the documents are silent or there's no restriction on how many people per room? Can the board deny it? Then I'm not sure what you would be denying it based on. You need to have that limitation in there. There may be something, and you'd have to sort of do a little research on this. If you thought, 10 people are applying to move, that want to rent this 2-bedroom unit in our community. Well, odds are, even if there's nothing in your declaration, there's probably a code or ordinance limitation, and your documents probably say that everyone has to follow all of the local codes and ordinances. So if you can sort of tie those together to say, well, the code or the local code or the local ordinance says you can't have more than 5 people in a 2-bedroom, then maybe you can tie those together to say, oh, then this would be a violation because you have to follow the ordinances, and you could deny based on that. But you'd have to look at, again, what's going on there. Live-in caregiver, background check or not? Good question. So again, that's somebody that's sort of in that gray zone. Do you want to be able to review everybody? So do you want to be able to approve or disapprove a live-in caregiver? If you do, make sure you have that authority. If you have the authority, you could ask them to do a background check. It's the same thing as, we get questions, hey, my boyfriend's moving in. Does he have to do an application? Well, depending on the governing documents, he might have to. So, just depends. Shouldn't an estoppel be required to transfer a unit? Yes, even by quitclaim deed. Well, technically, again, it's sort of between the parties, but that's separate from the transfer fee, just as a quick FYI. Let's see. In regards to the Broward Miami-Dade ordinance and providing approval denial to a tenant application, is this new? No, well, it's new-ish. Now it's probably, I don't know, maybe 5 years old. I've lost all sense of time, I'll be honest, in this COVID world we live in. It's 15 days that you have to respond in terms of a incomplete application, and then 45 days if you're going to deny. And Jennifer, if you want to email me, I can send you the links for those, just so you can have the information. What if the owner changes corporate names and doesn't inform the HOA? So same kind of situation we mentioned. essentially it's going to depend. If your governing documents require that every transfer of title requires notice and or approval of the board, notice to the board, then that person is supposed to tell you when they do that. Even if in their minds they're saying, but I'm still essentially the owner. It's my company that I put the, the unit in my company's name, but it's still me and I still live here and nothing else has changed. And that may be the case. We get that a lot where there's some confusion about that. But ultimately, if you become aware, you can send them a letter and say, hey, listen, our governing documents require that you still go through the process. You still have to apply. So please fill out the application and presumably it'll all be okay and you guys can approve it and you're good to go. Is it a good idea to establish a screening committee versus the president making the call? Now, again, your docs may require that there be a screening committee set up, so you might want to look and see what the story is there. Otherwise, typically, yeah, you could set up a screening committee. You could have the board do the review. Generally, I wouldn't just have the president doing it because really the president shouldn't just be making all the decisions on their own. So probably a good idea to have a committee, but you could have the board do it too. That's also fine. Do we have to accept 2 service dogs for 1 unit? Hi, Bobby. Question there is essentially, do they have the documentation for both animals? And this is something that did change recently, but again, it didn't get too much better for you guys. It got a little bit better, where essentially now they do have to provide support for both of the animals. And if they have the support for both animals and, I need 2 service animals or 2 assistance animals or whatever they call them, and that's properly documented, yep, you're going to have to accept both of them. Sorry. All right. In the absence of a formal parking policy, does that prevent the HOA from towing cars? So question there is really going to be, what do you have parking rules? Are there parking restrictions? Again, I'd have to look at your governing documents. I'd have to see what the story is there before you just started towing, and you need to comply with the towing statute, which is 715, different statute. And presumably if you hired a towing company, they would know that and they would make sure you guys get that all in order, but that's something you want to check on too. If you do that and you have the certain restrictions in place before you just sort of start towing, if you've never towed before, we would suggest, send out a memo, let everybody know, hey, parking's gotten a little out of control lately. So as a reminder, these are our restrictions or these are our rules. And starting on X date, we're going to start towing, give everybody a heads up before you start towing anybody. And then if there's a specific problem person, you can maybe send them a notice, let them know, hey, Mr. Smith, you keep parking on the swale. You're not allowed to park on the swale. Keep doing it. We're going to tow you. That's usually enough to sort of scare them. Rosario, you said, can you contact me later? Sure, no problem. All right, I think we covered most of them. I know it's 2:14. Phone number for the firm, 954-928-0680. Otherwise, our website always has a lot of information. And I'm sure if you guys are here, probably already signed up, you get our blast. I'm sure you're on our website too. But check that. We publish morsels. We publish articles of hot topics, things like that. kbrlegal.com. My email, if you want to reach me directly, is egannon@kbrlegal.com. So EGANNON. Luckily, it's pretty easy and short and easy to remember. That's the easiest way to reach me. I'm here a lot, so don't worry. You can get me one way or the other.